Thank you, and I appreciate being asked to speak today. Of course, I wasn't, when I was asked to participate in this board, it was probably later on into your guys' grouping. I'd missed a few meetings and I hadn't been able to participate. So as my previous presenter said, I'm extremely thankful that the boards exist, that you guys are out there, that you're reviewing this stuff, and that the legislature has put you together to talk about these issues. The reason it was important to me is because I do sit behind a bench in Valencia County, in Las Lunas, and we can easily get lost in our little world, in my little box of just what's going on. Well, in my little world and in my courtroom, there's a lot of problems with the domestic violence cases. So when I was looking around saying, what the heck is happening out there, and is it just me or what's going on? You know, then I got plugged into some boards, and now I'm speaking and I don't know what the heck to say. So, but there's just a lot of stuff that I think we all need to do better, and number one on that list is communication. I think if you guys can understand where we're coming from, maybe we can understand where you're coming from a little bit. And one of the things that I learned in one of the trainings I went to was that stepping off from the bench and doing educational touching out to the community, reaching out to the community is always something that we should do from the bench, because not everybody understands how complicated and difficult it can be back there. So that is one of the biggest reasons why I'm here today. And I do want to be able to answer some questions you might have about, you know, the judicial element that has to do with domestic violence. So I'm going to cover a lot of different things here. And I might go kind of fast. I don't know how much you know or don't know, and I don't know how much is relevant or not. I'm open for questions. Stop me at any point. This is going to be very informal, so just let me know, you know, if you need a little bit more information. So as we stated, I am in Valencia County. I'm out in Las Lunas. Just a real quick go over here. You got your Supreme Court. There's 5 of them. This is going to be by ranking, if you would. Court of Appeals is right after. District Court, there's 94 of those, and I'm at the Magistrate Court level, which there's 67 of us. We are limited jurisdiction, so what that means is we have a little bit, definitely we have less jurisdiction than the district courts do, but we have more than the municipal. We are equivalent to what metropolitan judges do, which is here in Albuquerque. The only difference between a metro judge and a magistrate judge for the most part is, number one, metro has to be attorneys. Magistrate courts do not need to. And of course, the limited jurisdiction on civil matters is greater. I believe they can hear cases up to $20,000 versus we can hear civil cases up to $10,000. But so for the most part, that's really the only difference. Of course, you also have judges that sit in the municipal court and in the probate court. For the magistrate court, there's 33 counties in the state, and there are 67 judges. We are elected. We are not, well, of course you get appointed to the bench if there's a vacancy, but for the most part we're a political entity, okay? So we have to be out there in the community. We have to get elected by the same defendants, by the victims, by law enforcement, by the defense bars, by everybody. So it's a very fine line that we have to walk once we get into office. Once we're in office, however, there's a lot of things that have to happen in order for us to do our jobs. As I stated, you don't need a law degree to be a magistrate judge, which I'm glad for, by the way, and I support completely. There is a movement to try to get us law degrees, but I think a lot of my job is common sense. I'm going to hear 2 different things. I'm going to make a decision based off of the rules, and then I have to implement a sentence. It's been sent down by the legislature that we have to do. So I have discretion on a lot of different things, but again, I think that doesn't require a law degree to do that. So just to put a plug in for that. Of course, once we are elected, we have to go to mandatory trainings. They send you off to a 2-week course that you have to take. Then you have to do so many hours every year. And then if you're a really motivated judge, there's trainings and programs all over the place. And so you get yourself involved as much as possible. Yep.
Judge, how many, can you hear me?
I can.
How many hours of that mandatory training is domestic violence related for your?
Not much.
For your job?
Not much.
How much is not much?
When we do our annual magistrate conclave where we're in training for a whole week, a domestic violence segment might run 4 hours in a whole week of training, okay? Now, when you first take the bench and we have to be in there 2 to 3 weeks in training, domestic violence might cover 2 to 3 days, okay? The type types of cases that we hear in magistrate court are numerous. Okay, we're a very, very busy court. We do all first appearances to all charges, meaning felonies. So anybody who's arrested for anything in the county is going to see a magistrate court judge, and that's to inform them of the charge, inform them of their rights, and to let them know, make sure they have an attorney, and begin the process. We're the start of every single case that gets filed in every charge if somebody is charged with a crime. We also do DWI charges, first through third offenses. Fourth DWI offense is a felony. We would do an arraignment on it, but it would get sent up to district court. We do all misdemeanor domestic violence cases, aggravated, non-aggravated. That can include violations of restraining orders. That would also include criminal damage to property, false imprisonment, interference with communications. There's a lot of different charges that come into play with the DV case. We do all other misdemeanors that could be anything from a driving violation, revoked driver's licenses, to shoplifting. We do civil cases, suing somebody for their vehicles, repair work that maybe did or didn't get done. We do a lot of water right share agreements, which are very boring. We also do landlord-tenant, where we evict people who don't pay their rent, and we do all traffic charges. So as I stated, that's a lot of cases. In Los Lunas and Valencia County, we're a big court. There's 3 judges. We sit on the bench, 1 in Belen, 2 in Los Lunas. And I believe, although I didn't pull the numbers, I think we have, I want to say maybe 5,000 cases filed a year in our court of everything. So it's a big docket. I start here at probable cause determinations because this is where we see all cases straight on. When an officer arrests somebody for any crime in the state of New Mexico, a criminal complaint is filed by that officer. The defendant is taken to the county jail if it's going to be an arrestable offense. He needs to do this in writing. He needs to swear to it, and it's when he transports the defendant to the jail, a copy of that complaint is given to the jail. The original complaint is filed at magistrate court. It has to be filed at magistrate court within 48 hours of the individual's arrest, and it needs to be the original copy. These are big deals when it comes down to the officer not doing this, so that's why I mention it. It's also the duty of the magistrate judge at that time to determine if there's probable cause for the arrest. Did the officer do everything he was supposed to do, and did this person probably do this crime? That's how I keep in mind what probable cause is. Did he probably do it? You know, of course you're not determining guilt or innocence here. You're just, as an average person, going to say, yeah, this guy might have done that. 48 hours. We are responsible for setting all the bonds for a defendant who is arrested for any charge. In Valencia County, we do use a bond schedule. So if somebody gets arrested or charged for a crime, the jail is going to use this schedule. Numerous charges are listed on that schedule. For instance, a domestic violence charge will require a $10,000 only cash bond at arrest, which means that this person cannot get out of jail until he posts either $10,000 in cash and/or he sees a judge. We have that number there for a specific reason. Most people can't put $10,000 up to get out of jail. Have I seen people do it? Yes. Have they? Yes. Majority? No. So that means a couple of things to us. He's going to sit in jail. There's going to be a little cooling off period. We can make sure, hopefully, if the victim needs to gather stuff and leave, kids, whatever. We do that for more just everybody to calm down and be, hopefully no, I guess to make sure the victim is safe would be one way to put it. For instance, a first or second degree murder charge, which we also do arraignments for, might have a bigger bond, a $500 cash only bond. Now, if the defendant posts that bond, and as I've stated, a domestic violence offender has in my county posted a $10,000 bond, he's going to post that and get out of jail before he even sees a judge, before we've had any opportunity to talk to him about anything that happened that night. If he's done that, he will sign a condition of release form that says he posted this bond. He understands he has to appear in court. He understands that he's supposed to stay out of trouble and have no contact with victims or witnesses in the case, and that he'll be present in court. Now, I'm assuming he reads this. I hope he reads this. Does he read it? I don't know. Does he follow it? We don't know, okay, but we do make him sign it. And then at that time, the court will summons that defendant into court within 30 days of the date of the offense. And that's the first time he'll see a judge. So here, this incident happened at this time. He may not even see a judge till up to 30 days later. Now, if he's unable to post the bond, and as I stated, sometimes the dollar amount for that bond is put so high to keep him there until he does see a judge, because we want to talk to him before we release him. We also want to review the charge. What happened? What went on that night? Keep in mind that if he didn't post bond, he's going to see a judge within 4 days of his arrest. Normally it's a lot less than that, and by law we're supposed to get it done a lot less than that, but that's the worst case scenario. So he has sat in jail from anywhere from 24 to 72 hours before he sees a judge. Normally these are done through a video equipment. I'm in my courtroom there at the jail. It's an open court hearing. Anybody could be present for this hearing. In my county, in Valencia County, it's usually just myself, a staff employee, and of course at that end it'd be the jailer and the defendant. Of course the DA can be present, the defense counsel can be present, the victim can be present, family members can be present. However, majority of the time in my courtroom that does not happen. So I'm explaining the charge, I'm reading the defendant his constitutional rights. He at that time is, he has the option to plead to the charge. We caution them, because we do let them know if they do plea at this point, they're waiving their right to a trial and waiving their right to an attorney. So majority of them do not plea at this point. But if it is a misdemeanor domestic violence charge, they can. If it's a felony charge, of course, they're not going to plea. The role of the judge is just to make sure that they understand their rights and that they do have an attorney, or we appoint an attorney if they need one.
I'm sorry,
Go ahead.
So that means that DA doesn't routinely appear at your DV magistrate court
Exactly.
arraignments?
I could probably, I know in Metro Court in Albuquerque, I'm going to guess, in the DA left I know here, but I would imagine in Las Cruces and maybe in Santa Fe. From what I understand in my communications with some of the other judges, there will be a DA or a victim's advocate present for the arraignment, okay? I just can tell you in my county that's not a practice.
And so what kind of information do you have at your disposal when you're making decisions? You get into that.
We're going to talk
Thank
about
you.
that. Yeah, we're going to talk about that. I'm going to talk about it, but I want to mention this case first. If you've noticed, and I'm sure you have, it's in the news almost every single day, there's been a big discrepancy as to why these guys keep getting out of jail. Why is your repeat offender out on the street the next day or two? A lot of it had to do with this case right here. State versus Brown is a new case. It was a case that went before the Supreme Court where a decision was filed by the Supreme Court in November of 2014. Well, who is Walter Brown? And again, this is just a review. I don't have any details about the case other than to say the way we were instructed was, number one, he was charged with murder. Number two, he could not post his bond. So now you have to figure, and my guess is at this stage of the game, he had already had a preliminary hearing. He had already been appointed an attorney. There was some determination that there was a probable cause that perhaps he had done this, and a district court judge set his bond. Okay, so his bond was set. He couldn't post it. Okay, and it was a high bond. It was a financial hardship on his end. Well, after 2 years, he was found not guilty. He sat in jail for 2 years, okay? I don't know why he was found not guilty. I don't know if it was a full trial or if for whatever reason it got dismissed. I'm not sure, but whatever happened, after 2 years, he was not guilty of the charge. Within that 2-year time frame, he lost his home, he lost his job, he lost his family, all because he could not post the bond that was set. So the Supreme Court's ruling was that money cannot be the reason somebody is kept in jail. Okay, we can't, it's not a poor man's jail. We're not supposed to be using or basing any of our decisions off of money. We have to base them off of other things. So they kind of changed the way we do things. It wasn't a new law. There wasn't a new opinion. There wasn't a new anything. The requirements for a judge to set bonds were already and still apply today as they did before 2014. But what the Supreme Court said is now we need to follow this. They're going to watch us and we better document it in all our files. So a new bar was set, and that bar is everybody must be released ROR. Number one priority is everybody should be released ROR, on their own recognizances. If you're not going to release somebody on their own recognizances, as a judge, you need to state why, and you need to state why in writing. So, what are some of the reasons we would not release somebody on his own recognizances? Well, we would not release him if he's had several failures to appear in court, which means the minute he walks out that jail, he's not going to come back. We know it because there's a history. Perhaps he has a pending charge somewhere. He picked up this new charge, and depending on the type of charge we're talking about, if it's a violent felony or perhaps a violent misdemeanor, that might be a reason why we just don't want him to walk out. Do we believe, or does the court believe at the time of arraignment, that this defendant may commit a new crime if we release him? So if these things happen, then of course the court can at that point set a bond if we choose to, or we can also set other kinds of conditions of release. Now, conditions of release are decisions that a judge makes at the bench at the time of the arraignment as to what rules they want the defendant to follow if we release them from custody. Now, you asked the question about where do we get that information from. Up until, I'll say 2, maybe 3 years ago, we didn't have this access at all, zero. And I will tell you, there's still some judges on the bench that don't use it at all. But what we have now is what's called Odyssey. It's a data program, a data system that all the courts have logged on to in the state of New Mexico. So I'm aware now, which took several years to implement and several years to perfect, I'm aware now of a person who may have been charged with a crime in Albuquerque, and now he's being charged with a crime in Las Vegas. Up until 2 years ago, there was no way for a judge to know this. Okay, we didn't know this. I didn't even know if somebody got picked up in Las Vegas and had picked up a new charge in Belen. I didn't know this, okay? So unless, so I want you to understand from the bench, that's something we never had access to, but now we do. So because of this computer system we do have a criminal background for all defendants if he's ever been charged with a crime in the state of New Mexico. We don't have the NCIC that law enforcement has, although they are working on it, and I think because of Brown, eventually the judges might have access to that kind of information. But we also need to consider not just his criminal background, the elements of the crime. Does it look like the officer did a pretty good investigation with the wording that he put in his criminal complaint? We have to determine if this defendant has any ties to the community. We need to ask questions whether or not he's got an employment or job. We want to know whether or not there's children involved. Is there, things that we will ask questions from the bench to try to get some of this information. And then of course we also, one of the things I always really look for is, does he have pending cases, and whether or not he was on conditions of release from those cases. Because if he was on conditions of release on another matter from another judge for another crime, he's violated that condition of release, and that judge should know about it, okay? Because they can revoke his release, okay? Not to mention, I don't have to let him out because now I know he's going to commit another crime. Odds are he'll commit another crime, so that's not an ROR. So these are some of the things that we look at when we're talking about conditions of release and options available to us in Valencia County. For me, standard conditions are basically no drugs, no alcohol. I don't want you to be in bars or liquor establishments. If you don't have a driver's license, I don't want you to drive. In a domestic violence case, I don't want you to have any contact with the victim. Now, when the way I get to that condition would be after that conversation with the defendant. Are you married? Are you not married? Do you live together? Do you have a place you can go? This is where you find out if mom can come in, or a sister or a friend, if he can go stay someplace else. You find out whether or not there's firearms in the home. You find out whether or not the officers took those firearms. These are the questions that you're asking, and so you set the conditions of his release. We in Valencia County are lucky. We have a pretrial services division. Not all counties have. And it's kind of like a probation office, if you would. They supervise them. They'll drug test them. They're going to make sure that they stay away from the victims if that's the order of the court. They will, whatever other special condition might be, they'll make sure that the defendant is following the conditions of the court. We could do a third-party release, which would mean we could release you to your cousin or your uncle or your aunt or mother. In a DV case, a domestic violence victim cannot post the bond for the defendant, they cannot sign the third-party release for the defendant, and they are not allowed to get him or pick him up from the jail. Okay. Now, we do have those policies in writing between the courts and the jail. Are they followed? Are they checked? I hope so. You know, I'm going to be operating from the premise that it's working, but that's one of the things that we also require. And then we do have access to alcohol monitoring, GPS monitoring, especially if we've got a violent offender out there. We definitely don't want him anywhere near the victim. A GPS monitor would be imposed to determine that he have no contact. And we put it in through ranges. That's how he stays away from the victim. Okay, so let's say we've got the domestic violence. One of the things I wanted to touch base here that I find that magistrate court is important is because what I've noticed over the few years, I've been doing this about 10 years now, you've seen a misdemeanor domestic violence 2, 3, 4 times, and eventually he's getting, you know, more violent, and then it becomes a felony, and at the felony level, that's where you get your action, okay? I'm seeing the DA come in and out and in and out with the same defendant, it not going anywhere, it getting dismissed. But now he almost killed her or did kill her. Now we got a felony attorney on it. Now we got somebody working on it. And now we're going to get some, hopefully, resolution for the offender. That was my biggest problem. I think if we can fix it at the magistrate level, maybe, you know, not gonna fix everybody, and I do know that. I'm not you know, in dream world. But I do also think that we should start at this level. I think magistrate court has a big role to play in offenders, and I think we're not doing a good enough job at it at the court level. I know or believe in my county we're not doing a good job of it at the prosecution level, and this is where I think some of the changes need to be made. Now, on a normal docket, all domestic violence cases are set for a pretrial conference. The DA will enter his appearance. The defense counsel is appointed. In our county, a lot of them are public defenders. We talk about discovery. We talk about interviews with the victim. We find out if the victim's going to be participating in the case. They determine if it's going to be a bench trial or a jury demand. And this whole process of pretrial conferences can take anywhere from 30 to 90 days. Now, the DA did not represent or prosecute in domestic violence cases in most counties up until about 3-4 years ago. There were counties where it was still officer prosecuted. Valencia counties had the ADA on board and the district attorney's office for about 7-8 years now, which is a good thing because it's something that didn't happen before. That is a requirement now statewide, so again, I think we're making progress. Victim participation. Well, as you heard from the DA prior, and I think that this is probably one of the frustrating parts that we see from the bench, it's up to the DA if they want to proceed on a case without a victim. I try to find out this information in a pretrial conference early on because I know my DA and how hard he's going to work to try to prosecute that, okay? Because in my county, that is an issue. For some counties, a DA will go forward even if the victim isn't participating. In my county, they won't. Problem, big problem. We, at that time, at the end of the 30 to 90 days, we're either going to have a bench trial, we're going to have a jury trial, or we're going to have a plea offer and a sentencing. And that's typical in that standard.
I'm sorry, this is the end of the first 30 days of the case?
The trial setting?
What did you just say, within 30 days?
No. Well, within the 30 days, what they're going to have decided, hopefully, is that this whole process of pretrial conferences will happen between 30 to 90 days. So we could have up to 2 or 3 pretrial conferences before we actually have the trial on the case. Okay?
Is there a statutory determine that deadline?
There really isn't. We have 180 days to get the case prosecuted, okay, or heard or dismissed. So between the 30 and 90 days, what we're doing here is that first 30 days is just talking about discovery. Did the police officer turn over everything? Do we have the videos? Do we have all the name and addresses of everybody and blah, blah, blah. The second one is, okay, an offer was made. No perhaps we don't have the victim participating, and there's a problem, perhaps an officer isn't around no more or has left or something like that. So that sometime within that 90-day setting is when the actual trial is going to be held, if there's a trial. And I say if because in my county we don't have a trial. Been on the bench a little over 11 years now. 2 trials for a domestic violence case.
11
2.
years.
Everybody please, or it gets dismissed. If I'm lucky enough to get a plea to a complete domestic violence charge, okay, a battery on a household member, if I get a plea, he will be sentenced to the mandatory 52-week program. He will be sentenced to alcohol and drug testing, because we do in Valencia County have a compliance office. We have a compliance for DWIs and we have a compliance for domestic violence. So there's 2 different programs. They're housed in the same place and they're run by the Village of Las Lunas. They're great. I love them. I love them. And they're doing a very, very good job with very little that they have. They can't do home visits. They can't do some of the stuff that was asked earlier, but they do have the ability to bring in the defendant, to drug test him, to question him, to make sure he's doing his impact panel, to make sure he's doing his batteries intervention program, excuse me, and that he's complying with all of the court sentence, okay? Is he making his payments? Did he do his donations? Whatever's going on. If he is supervised with adult probation and parole, we can put him on supervision for a period of up to 2 years usually. And of course, through adult probation and parole, he'll also be drug and alcohol tested. He has to comply with the program, and any other violations will be brought to the attention of the court. He could also be sentenced to unsupervised probation. We've done a few of these, and these happen to usually happen if perhaps either the victim or the defendant is no longer living in the state. Okay, so there's like no contact any longer. Perhaps he can't do the treatment program in Valencia County, and he's going to be going back and forth to Texas. One case that comes to mind is he was working on an oil rig in Texas and was only in Valencia County a few months out of the year. We couldn't really mandate him to that 52-week program, so the compliance office worked with him on an unsupervised thing, just basically making sure he stayed out of trouble. Now keep in mind, those kinds of cases, they weren't, the plea probably wasn't to a domestic violence charge. It might have been to a lesser included charge. If he gets unsupervised probation, he might still be court monitored, and when I mean court monitored, the staff, I'll make a note that I want this to be statused in 30 days, 60 days, 90 days, whatever, because I want him to bring in proof that he's done something that the court has asked him to do. He's imposed court costs on every case that he pleads on, and every charge he pleads on, he will pay a court cost. The CVR fee is a new fee that got imposed. I'm not sure if everybody's aware of that, but it's a crimes of victim restoration fee, yeah. So as of July 1 of this year, that fee started to get imposed. So an average charge for domestic violence court costs with the fee would be $123, okay? That's what the defendant would be as far as the fee goes. We can impose a fine, depending on a petty misdemeanor or a misdemeanor. It could be up to a $500 or $1,000 fine for the charge. In most cases, for domestic violence, I'll try to do a donation to the shelter instead. I'll say instead of imposing a fine, you're going to pay the court costs and you're going to make a donation to the shelter. That isn't a requirement, just something that I'll do. Or again, we can always fine them and the money will go up to Santa Fe. The following are what I have noticed are what I think are problems that are going on in Valencia County, and problems that I'm seeing on how the DV cases are handled, and why I still think this might be a problem in our state. Almost all charges are reduced, okay? And as the DA mentioned, sometimes that's the best they got. And that's fine, I get that. Understand that a judge doesn't have a lot of discretion in that kind of stuff. We can either accept the plea or not accept the plea. In almost all cases, we're gonna accept the plea. If the parties have worked this out, we're gonna let them work it out. And then whatever the plea is and whatever the charge is, we're kind of stuck into what we can sentence. But in our county, a lot of battery on a household member charges are reduced to a simple battery. Now, simple battery has a whole other different type of requirement, and it isn't a treatment program, so that's why those guys aren't going to treatment. Battery on a household member, and this is done regularly, is reduced to a disorderly conduct. Okay, that's another petty misdemeanor charge, does not require any treatment or counseling, doesn't even require any supervision. So if I get any of these pled down, he's going to walk out the door paying $100 maybe and a donation and see ya. Okay, that's regular.
Do you have any control over keeping, like the 52-week treatment, maybe being attached to some of those treatment charges? Was the nice treatment
We could, and we have, but the 52-week program is almost a year, right?
Yes.
Okay. A petty misdemeanor, the court only has jurisdiction for 6 months. So I can't require him to do a 52-week program because there's no way he could finish it in the 6 months that I have jurisdiction on. So which would mean that if he didn't do it, there's not a darn thing I can do to him.
So I guess my question though, for example, is it on? Yeah, it's on. Well, it's yellow. Yeah.
I think our program, I won't speak for everybody, would be open to having somebody in that program for 6 months if that's what the court would order. So I guess not so much about the 52-week supervision part of it, but you could hold the mandate for the referral to the program, whether or not it was for 52 weeks or not. I guess that's more my question, is whether or not you could keep, so if the DA brought back a plea that included these charges where there's not a requirement to refer to a batterer's intervention program, can the judge say, I'd like you to include treatment in this
Yes.
plea and then I'll accept it?
Yes, the judge can. Again, keep in mind that, number one, we got to know that you would do that, because we may not know that you would do that. And number two, keep in mind that we wouldn't have jurisdiction if he doesn't comply. Okay, so that's really where it gets down to holding the offenders accountable. Okay, that's the hardest part. It's what I hear has been probably one of the most challenging. So keep that in mind. We can order it, but if he doesn't do it, what are we going to do about it? Okay. And keep in mind, I just put here different sentences, of course, or different types of supervision, and in most cases, none of these are going to require treatment. One of the things that I do notice that we do a lot is we have a batterers program in our county through Valencia County Shelter, but we also have agave treatment program, and it's a very nice treatment program. It was built in our county a few years back, and I think that after some bumps in the road, they have a program manager who's doing really good with the treatment there. But they do all kinds of different treatment. So if we send them to an assessment at Agave, which we do a lot, and whatever that assessment comes back at, and don't ask me what tool they're using, I have no idea, then they tell me what kind of treatment that they need, and then I'll tell them in the sentence, whatever that treatment assessment comes back as, that's what you're going to be required to do, and you have this much time to get it done. So we rely on those assessment tools, and we rely on the fact that whatever is required, we're going to make him do it. But because of the time frame and what they've done in reducing the charge, there's not a lot we can hold them accountable for.
So if somebody is like convicted of battery against a household member and they have to do the 52 weeks of BIP, and they're only on probation for a year and they don't complete their 52 sessions of BIP within that time that they're on probation, can the court extend their probation period to make them finish the 52 weeks?
Okay, good question, and I'll get there, but yes, the answer is yes, but let me tell you why. It's because if he violated, then I can increase his probation time. Okay, if he didn't complete it within the time frame I told him to do it in, then I can increase his probation to include it if I need to. But I can only do that if I knew there was a violation, he didn't do what he was told to do, and perhaps I had to put a bench warrant out there because he failed to appear, just whatever had happened with the violation, then I can. But if I don't know, and come to the end of the 6 months and he did 25 of the 54 and my 6 months are up, I can't do anything. I've lost time on him. So we got to stop the time, and the only way to stop the time is to know of the violation and to issue the warrants or whatever have to happen. Nothing else will stop the time.
How was that communicated to you?
We'll talk about that.
Okay.
Let's get there, okay? So let's talk about reporting, okay? So keep in mind, on this one I'm talking about something different. One of the other reasons I'm here, thank you, is that when I was getting into Betty Caponera's reports, okay, which I found very, very interesting. That's how come I know how bad Valencia County is at doing this job. I found out that our Valencia County Sheriff's Department wasn't even reporting domestic violence calls to them for statistical data. Our Las Lunas Police Department was not reporting their data. Those are the two biggest law enforcement agencies in our county, okay? So if you get a number from some report prior to 2015 that says, there's this many calls in Valencia County, it's not an accurate number because these two agencies weren't even reporting to that statistical information, okay? We've since mended that fence, I believe, and they are now reporting. And really, we had a change of law enforcement here, so the chief of police is a different person. The one up there, I don't know what his problem was. I guess he just didn't want to do it. So, without knowing that, I was like, so I was thinking, okay, well, we don't have that big of a problem. And then they submit their numbers, and it's a whole other different skew of numbers. So when you're looking at statistical information, keep that in mind, because not all agencies were doing that. And then, for instance, state police, they don't record how many came out of Las Lunas. They report by region. So, that could be with Torrance County, Valencia County, Bernalillo, and Sandoval. You don't know. So, look at those numbers and just understand where they're coming from and how they're put in. I also think that training is a big deal. And she did mention from the DA's office that it's kind of the job of the DA to do the training of law enforcement, okay? And every DA does this a little bit different, and every DA is also a political office, and they have different agendas. Some are priorities and some are not. My DA is very, very active in the DWIs, and that's a big deal to him, and his numbers and dismissal rates mean a lot. I don't think he feels the same way about domestic violence. I could be wrong, and I'm being recorded, but it just doesn't seem to be as a big a priority. So based off of that, I do know that all DAs do that a little bit different. We do have a CCR group. We do have a SART group. We have different kinds of community organizations that are there to try to hold us accountable. I've been to a few of those meetings, and I'll tell you they're very low participation, and they're not getting a lot of community input. And all law enforcement agencies have a different policy and procedure on how they handle a domestic violence call. So now that the DA has entered his appearance this last 5 years, I see that it's gotten better. They are working with the agencies, and a lot of the agencies are doing a lot of the same procedures. But up until a few years ago, that wasn't the case, not in Valencia County. Advocates and the committee involvements are extremely important, and again, it's up to the DA to work with these organizations to train them. I mentioned real quick the Odyssey and the computer talking to each other here in the state. That was a big deal. In Magistrate Court, all of us were done by 2013. In Metro Court, Albuquerque was converted in 2014. So up until then, I didn't even know what was happening in Albuquerque. Now I do. Keep in mind that prior to Odyssey 2, all the courts were entering their charges different, okay? So you might have had a violation of a restraining order may not have been a domestic violence, flagged as a domestic violence call. So the DA may not have been reporting, and we may not have had that same charge filed the same way in a different county. So those numbers were skewed as well, yeah.
I'm wondering what information is in Odyssey that's not in nmcourts.gov.
I think just personal data information, addresses, phone numbers, stuff like that. Everything else is in New Mexico courts.gov.
So they're essentially the same, so okay.
Not completely, but mostly.
Protection.
Pardon me?
Orders of protection,
Orders of protection are not in there?
not anymore.
Okay.
I guess, so my question about that, because we've, as part of this task force, talked a little bit about being able to get a clear picture of what someone's criminal history might be. And so I'm wondering if there's information in Odyssey that would be available to BIP to be able to get a clearer picture of that, or if it's a confidential only for
I believe it's
courts?
there
Okay.
would be some confidentiality issues with Odyssey because it is just a courts thing. The judge makes notes in there, staff
Okay.
makes notes in there. So I would imagine there's probably some issues there, what they are and how to go about it, I'm not sure. But like I said, it's not foolproof. What I did like that I heard earlier was that the communication of the police reports and the to BIP and you getting a real true picture of perhaps what happened that night that brought this defendant to you. I loved that idea. I loved it, because I never had thought about something like that and how that could make such a big difference in the treatment element of what's happening. I'm wondering if the victim's advocate wouldn't be a good source for passing on that information to you. If it is something that requires an MOU with law enforcement, I don't know what kind of confidentiality issues would be there or not in New Mexico if the statutes would require it, or allow for it, excuse me. But it sounds like that really is such an important link, because even if you do have him on a disorderly conduct, or if he came to you on a simple battery, you would really want to know what caused him to even be there in the first place. And I guess I never thought of the fact that perhaps you didn't know that. And so knowing that you need that makes so much sense to me, and I would like to see that be a requirement, because I think that that's a really good idea. For probation violations, if I'm made aware of a probation violation, we're usually made aware of it through a new charge that the defendant has picked up. We know about it if we find out that there's no compliance, or if he stopped going to treatment, or if he's missing a lot of treatment. And we'll also know if he's just not reporting for his supervision. If any of these things happen, he is required to get an arraignment, and he's also required to have an attorney. So that slows everything down, because he doesn't have to admit to the violation. He can deny the violation. So if he does that, we got another 30 days before we have a hearing to determine whether or not he violated his probation. One of the things that I need to check on, because it's been raised here with this group, is the treatment portion of it. I don't want to know about him missing treatment 60 days down the road. I want to know that he missed 2 back-to-back treatments right away, okay? And somebody had asked me in the group earlier, well, how do you let the judge know that? How does the judge find that out? Well, of course, in my county, because I have a compliance monitor, my compliance monitor needs to tell me that. If it's through adult probation and parole, they need to tell me that. They don't come to say, hey, judge, he missed. They file a document with the court asking for a hearing. I review it, and then it's called an affidavit of non-compliance, or perhaps it's a motion to revoke. It could be lots of different things based off of what the violation is, but they file it. Once it's filed, the staff knows to set a hearing, and then it's set for a hearing. One of the things I worked with my staff is that if you see one of these, you don't wait 30 days to set that hearing. You set that hearing within a week or 2. I mean, get it set right away. Because he may ask for an attorney. He may deny the allegation, so that draws it out. So, or he may fail to appear. So let's say he fails to appear in court, but he had missed 4 treatments prior to that. Did the victim get notified? Did she know? Do I know? Does the court know? And so all this time has gone by, and did we really protect her rights, you know? So those are just some of the challenges that I see that happen with the violations. Now, keep in mind, we got everybody in the room. He's showed up. He's not doing his job. I'm made aware of it through probation, supervision, or compliance. Then I need a recommendation, and I need a stiff recommendation. I want to know what you guys want me to do with him, because you leave it up to the court. And I say that not just because me personally it's helpful, but I think for all judges, because you're going to get judges that are going to do different things. They may let him walk out that door and not do nothing about it, or they may say, you know, no, you're going to serve the rest of your sentence in custody, whatever the case may be. But it has to be given to us as an option, and it has to be told why that's so important to us, okay? So whether it's the DA that's making that recommendation, or compliance, or probation, you know, probation is almost always going to say, just put him into custody, okay? But, and that might be what we have to do. But tell me why is it because he's missed 15 appointments, because he's contacting her and he shouldn't be contacting her? He tested dirty 4 or 5 times, and you know, he failed to appear for his last 5 treatments. that's a good reason why he needs to be put into custody. But if I don't know that and it's not outlined to me like that, you know, oh, we're willing to take him back into treatment and into probation, supervised, okay, then I'm going to give him that too. But he got no penalty for doing all the stuff that he did before he agreed to it.
Judge, can't you do a combination saying, oh, you know, for your violation, you're going to serve 3 days or whatever, and then you're going to go back to the
Yes. Yes, you can. And those are all good things. And like I said, that's why, of course, your defense attorney is going to say something and your state is going to say something, prosecutor or compliance. Yeah, you're going to get the middle of the road for the judge. Usually you're going to get the middle of the road. But give us those options. If we don't have those options available to us, you know, you're going to get who knows what, because every judge is different. But you're going to get different sanctions, different punishments. Couple other things, and I know I'm almost done, so if you had any other questions, these are some of the issues that I think that I've addressed already. You know, bonds, conditions of release are a big deal. Brown was a big deal. If they take away our bond schedules, keep in mind there's going to be some constitutional amendment changes that I think the legislature is going to be looking at. I'm for them. I'm totally for them. Give the judges as much options as you can to hold a defendant. If they take away that right to post a bond, I think that should be done. I think some of these defendants shouldn't have a right to post a bond. I think they need to stay in custody. I've seen a lot of them. I'm just as sick and tired of the repeat offenders as everybody else is. But we don't have the authority to do certain things. So we need some of these changes made, and they need to be done either through the legislature or through a vote, which a constitutional amendment requires. There's an ad hoc committee that is currently sitting to talk about those bond issues and conditions of release. If you aren't aware of that committee, you should look into it. I have spoken in front of that group as well in support of the no bond on some defendants. The message we're sending to victims in my county, I would say we're sending a message that we don't got your back. It takes too long. Too many things are in play here, and at the end of the day, if there's a plea reached, because 82% of the cases are dismissed in Valencia County. So, okay, and those could be for all misdemeanor domestic violence cases. So if 82% are dismissed, and we've got a 15% plea that's going to come in on a charge that's going to be reduced, what are we telling her? Okay. I think that we need better awareness in our community, through, whether it be through 911, through witnesses, through families, through a neighbor that might know something. Those people need to get involved, because you're not going to get the victim to testify, but you could get her neighbor to. Perhaps maybe a witness who saw something at the grocery store. The one trial I did, the one conviction I got, it was a witness. He was beating her up in the car at one of the grocery stores, and the witness is the one that called the police. The witness is the one that showed up. The witness is the one that testified. She got on the bench, said nothing had ever happened. He didn't do it. I found him guilty. It got appealed. 2 years it sat in appeal at district court, and I think this last year, the cop didn't show up and got dismissed. So he didn't spend 1 day in jail for the conviction I gave him. Let's see. Keep in mind that the DA and the defense counsel all have different views, right? They're there for a different reason, and they're there to sell their case. Most of the defense counsels won't plead to anything, especially domestic violence case. I think some of it has to do with this constitutional right to carry a firearm, because I noticed once that came into play, they won't plead to anything domestic violence. We have a lot of hunters. I guess that's the reason. I think it's important. I think they shouldn't have a firearm, but I did notice pleas changed. Affidavits of non-prosecution, these happened in a lot of counties up until a few years ago. Valencia County, we put a stop to them real quick. You're not going to do that. If the DA wants to nolly or dismiss a case, we'll let him, but I'm not going to let a victim do it. But up until a few years ago, the victim could do it. Huh?
How did you get rid of that practice?
I just told them we weren't accepting it. I still have defense attorneys say, oh, but Your Honor, I have an affidavit of non-prosecution. Oh, well, that's very nice. You can put it away. I don't need it. It doesn't mean anything to me. It may to the defense or to the DA, because if he has one of those, he may not move forward on a prosecution. Mine won't. Let's see. I guess that's pretty much it. Those were just some of the things. So I think I'm done. I'm open for questions. Somebody told me, and I agree with this concept totally, is the only person who can really hold that offender accountable is me. I'm the only person that can look him in the eye and say, you know what, you're not going to do this anymore. And in order for me to make that mean something, whether it be putting him in custody, putting him into jail, putting him into treatment, I got to know about it. I can't do it if I don't know about it. And you know, when you're talking about your BIP and whether or not it's a good program, whether or not it works, I hope you know that from the bench, I have no idea and I don't care. I trust you. If you tell me it works, it's going to work. I'm going to believe you. We're going to send him. If there's an argument as to whether or not it's working, if it's an argument as to whether or not the assessment or which assessment to use, I think it just causes more confusion among the judges. And because we're vast in our beliefs, you know, they may stop using it altogether. And I agree. I think something is better than nothing, and I want to see it stay. So,
Kind of along the lines of what I had asked about before about extending probation till they complete the 52 weeks. The curriculum that we use at my program, or at our program, is designed to be completed within 52 weeks. But there's a workbook that we use, and a lot of our offenders will complete 52 weeks of the program, but they haven't completed the whole curriculum, if that makes sense. Mm-hmm. Like, they're only in, you know, phase like 2 of the program, and there's 4 phases, but they've completed their 52 sessions because they're just kind of not doing the work and, you know, dragging it out. And so, but because their probation says they only have to do 52 weeks, they stop coming. And so, whereas in the real good stuff of the program is actually, you know, in that end piece. So is there anything that can be done with you know, magistrate court compliance, or with, you know, with the judges to word it differently, to say that they have to complete the, you know, the curriculum, or
well, let me just say, for a while, it took us a long time to get to the place where we put it in the judgment and sentence that a 52-week treatment was required. Sure. That took us a long time to get to that place, okay? Right. So now that we're at that place and we're putting it in there because it has to be there, right, for his constitutional rights. Keep in mind, we're keeping on top of all that. Mm-hmm. To change it, right, okay, like for somebody who, for instance, who we're going to say you're going to go take a treatment assessment and you're going to follow any treatment recommendation, you know, that's one way, and that's a big vast window, and that could mean a lot of different things, but at least that's open. Mm-hmm. Domestic violence required this 52-week program, and that's what it's called, is the 52-week batters program. Mm-hmm. Change the name of the program and don't call it a 52-week program, and then maybe that would do it, or complete the domestic violence impact panel program. I don't know, maybe take out that 52-week and that would solve that problem.
Or,
but
I mean, or is there a way that, I mean, if they are, you know, kind of like, you know, just dragging things out in the program, if we as the provider report that to their compliance officer, then the compliance officer may have some.
And let me tell you, that's why that works, and I know it's possible, is because we do it in our DWI drug court. I'm a drug court judge. I've been a drug court judge for many years now, and that's a treatment court. That's what it's all about. And a guy could sit in a treatment and just get by. Right. But the providers come back and tell us, this is what he's doing. He's not participating, he's not communicating. When we talk in a group, he's not talking in group. He's not doing these things. It's reported to us immediately. We know that right away in drug court because he's sanctioned for that. Okay. So we can do that in DV. We don't have DV courts in New Mexico, but you know, it is something can be done.
And I think part of that, we have to take responsibility as the battery intervention providers. I mean, I kick guys out. I say failure to progress. I send them back to the court. You can't call. You've been here 26 weeks. You haven't done your first assignment. You're wasting the group's time, you're wasting your money, you're wasting our time. You need to go tell the judge what's up. And I sent a letter to the jurors saying, he's here 26 weeks, hasn't done anything. He's spinning his tires. We need guys in here who are willing to work and do that. And I understand people, our court, we do it now. We say, must attend and complete the battery they report a minimum of 26, 36, 44, 52. So it's a minimum. And I don't charge a client after they complete their court requirement. We have nobody completed 26 weeks. It's just impossible. So most of my guys are 36 weeks to 52 weeks. And ours do it, certain guys have to do the 52 and some can do less. But I had another question for you, Your Honor. When the court is, when the prosecutor is offering a plea bargain, so it's no longer going to be a DV, do you guys still send them to batteries intervention? So let's say I assaulted my wife, but because of the firearm thing, and my wife isn't going to testify against me, they decide to plead me down to disorderly conduct or whatever you would do in here.
We wouldn't send them to the batterers intervention, but we would send them to Agave for assessment and any treatment required off of that assessment.
They understand domestic violence?
They do, as far as I'm aware, and like I said, they're one of the local providers in our community that I don't think they charge. They have a lot of different types of programs that they do treatment, which would be individual as well as group. And then, like I said, breaking it down to whatever that assessment tells them they should be treated for. So they may not be in the BIP, but they would be in some sort of treatment.
I was just going to piggyback on what you were talking about, Erin. And I know that for probation and parole, even if it's like a 54-week, 52-week program, if the program or the provider can articulate to a probation officer or the compliance monitor that, although they have completed these courses or they've physically been present for 52 weeks or whatever, they haven't done their curriculum or their homework assignments or so forth. I've seen it where judges we can do a violation report on that. So probation and parole, we can do a violation report on that and articulate that, hey, they're showing up, however, they're not participating in the program and so forth.
And I would propose you do that as soon as you know it's become an issue. You've got this guy, in group with you for, after 10 weeks, and you know that there's a problem, let me know as soon as you know there's a problem. The sooner you let us know, the sooner we can respond to it. Because like I said, keep in mind the court does have time issues, so, it's unfortunate and I wish it didn't happen, but it is what it is. And so if he has the right to some of these attorneys and arguments and constitutional things that I have to look out for, then the sooner you let me know, the sooner we could get him back on track. If you wait till the end, we're not going to do anything about it.
Do you have any insight into if a BIP is regularly sending non-compliance reports?
For me, I do because I have a compliance office, okay? So because I have a compliance office who works in the exact same area as the treatment and that whole good thing right there, and I have a very good program and I'm very proud of how hard they're trying to do what they're doing. So yes, they'll bring it to my attention, but again, it's not something that I think that they're doing quick enough.
So I guess
really like to see
what my question is, though, I think is that, so our BIP regularly sends non-compliance reports, but regularly does not really get any response from the court after that. So do you have any insight into how we could approach that with magistrate court judges, or what might be a common problem that would stop them from reacting or responding to that?
One of the things that we do that I think has been helpful is we have a quarterly meeting with our compliance office. We usually do it every 3 months. I have a law enforcement meeting. Right after I'm done with my law enforcement meeting, I go into my compliance meetings. Like I said, it's done quarterly, and then we talk about those issues. The DA's there, the compliance monitors are there. We have representation from the defense counsel, and then the 2, not 3, but we have 3, but only 2 judges usually show up for that meeting. But that's when we talk about those problems.
Who convenes that meeting?
Pardon me?
Who convenes that meeting?
For me, I did it. But I did it because, like I said, our compliance had just been created like 2 years now, and we're just getting into what the judges want to see happen there. So, but I think your compliance programs or probation can ask for these hearings with the judge, and the judge, You don't have access to the judge like I know that people sometimes think that there is, but there's not. We're very protected and sheltered in our court, and we don't come out and talk to anybody about anything. There's a lot of requirements of a judge to stay out of conversations and not to know too much. So that's a difficult thing for you to do. But if you have a magistrate court where the judge is open to having these meetings in the community, you're not talking about one case, one defendant, you're not dealing with any one thing, you're talking about the system, we can go, we can participate, we can hold the hearing, you know, the
And does your BIP attend that?
no, but they should.